We're live. Okay, great. Now we're live. This is Senate Judiciary. This is Friday, April 12th, 2024. We are joined by Eric Fitzpatrick, and we're taking up H 878, an act relating to miscellaneous judiciary procedures. We've already walked through the bill, and now we're looking at some amendments that are being offered, and I'll turn it over to Eric.
Thank you, Senator Sears, and good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here as the chair said to talk with the committee about a possible amendment to H 878, which is the annual miscellaneous judiciary procedures bill. Did the walkthrough of the bill last week, and now there's several new provisions or an amended provision of one of the existing sections to look at, and they are highlighted in yellow. I can point you to what pages they're on as I go through, and I'll let you know what each one involves. The first one is on page 9, and it would be a addition to section 12. And this has to do with, just to give you a moment or two of background, this has to do with the surcharge. You know, when someone is charged with a criminal offense or a civil offense in the Judiciary Bureau many times as well, in addition to whatever criminal fine may apply, there's a surcharge that's applied, and that surcharge is divided up between various funds. It goes to different places. There are different surcharges. In fact, there's another one or two as well. But this particular one that we're talking about here, a good chunk of it has always been divided up into two special funds: the Crime Victims Compensation Special Fund and the Domestic and Sexual Violence Special Fund. So a portion of the surcharge goes to each of those funds. Over the last several years, I think even predating the pandemic, both of those funds were running short on capitalization. I think you may recall that being discussed, that there was problems with the financial stability of both of those funds. So there was a report that the Joint Fiscal Office did that recommended various changes, including some additional portions of this surcharge being dedicated to those funds, so that essentially the way that they were allocated would be modified a little bit. So this is technical correction to that proposal that you're looking at right now. What happened was, in the budget last year, they made some language passed that would have done that would have reallocated these funds between the two different funds that I just mentioned: victims compensation and domestic and sexual violence. However, there was an error in that language that passed the budget. So this is technical corrections to that error, fixing it and establishing that going forward, this new reallocation is going to happen. So if you think of us, look at it sort of compared to the way it is now. So right now, this surcharge is $47. And of that, I'm over on page 10. And of that $47, $29.75 goes to the Victim Compensation Special Fund, and $10 goes into the Domestic and Sexual Violence Special Fund. The new language, page 10, lines 6 to 10, bumps both of those up a little bit. So the $29.75 goes up to $33.50, that's on line 7, and the $10 goes up to $13.50, that's on line 8. So basically, it doesn't change the amount of the surcharge. It's still $47, but it changes the amount that goes into each fund from that 47. So each fund gets a little bit more. And the idea is to add some more capital for that fund.
So just to add to the drama, been working with the Center for Crime Victims, and there will probably be a one-time $300,000 appropriation to the Center for Crime Victim Services to make up for the mistake, which created a one-time $300,000 deficit in their budget. Because they thought they counted on getting that money in their budget last year, and it didn't materialize.
Yeah, I think part of the technical problem, I'm not sure where the language originated from, but it was drafted to apply retroactively.
Usually last minute, they come in and want money.
Oh, right.
What they base that on? Was the year before's total budget? Because
no,
these are civil tickets that are issued.
Budgeted $300,000 based upon them getting these revenues. They didn't get the revenue, but they still spent the money. So to make up for the deficit, they estimated 300,000. I think they testified to that when we were doing the budget, but at the time, it wasn't clear to me what caused it. Now, this is what caused it.
And did they just discover this? Is that why we didn't address it in the budget adjustment?
Probably, yes.
Okay.
My understanding is the court recently discovered it as well.
Yeah, it was, where did the money go? Why didn't we get it? But somebody got
I
it.
was gonna say, where'd the money go?
Yeah, where did the money go?
Somebody got it and they're spending it. Who knows who? Probably the judiciary.
I think what I heard was that the judiciary didn't know about it till recently either. So the money was just allocated the same way it has always been. You know, wasn't
Anyway,
reallocated under the new.
so we're being asked to fix this problem in this. That's the truth.
That is the gist of it, yep. And going forward, it will be divvied up as it reads on page 10, line 6 to 10. So that will be the way that the allocations are made of that particular surcharge going forward.
But it does, the dates of 2023 is not 2024, so just keep that in mind, at June 30th, 2023.
Yes, the other thing I was gonna mention, it's an interesting point, is that so it applies retroactively, and that's in the we'll get to that at the end, but the very last section of the bill, the effective date section, that change applies retroactively 1 year. And my understanding is, you may want to hear more from the court or the Center for Crime Victim Services, but my understanding is that the court has been able to do some of this reallocation for, think about some of those cases, you know, they may have started back in early 20 or mid 2023, but they aren't necessarily completed yet. So there's still time to do some reallocation of the funds, and the court's been able to do that. So, so they were able to apply it retroactively 1 year, and some of the funds have been since reallocated, or at least can be, even though some of those cases have begun, they haven't necessarily completed yet. So there's still an opportunity for that. I should add too that my understanding also is that the court has worked with the senators, as you mentioned, Senator Sears, so they've agreed on this language as the way to fix the problem.
Just,
Yeah.
one thing I just want to confirm, there's not going to be any instances of the courts going to people whose cases have been adjudicated and totally finished and saying, hey, you owe a little extra money, by the way.
Correct.
There won't be any instances.
There won't be.
Just wanted to.
Yes, I think that was part of the problem with the way the language was originally drafted.
Yeah.
If you look at the changes made on page 9, that I don't know, I wasn't there when it happened, but it was written in a way that it would have applied to cases that had been already closed.
Yeah.
And the court said, we can't do that.
Right.
And I think that possibly may be why some of the anticipated money didn't appear.
Thank you.
So the
Yeah.
next change is,
The next change is on page 26. And this is, there's several changes, and these are all related. Remember, this is the idea of the Uniform Power of Attorney Act that you passed last year. Remember, it had 2 model forms in it, one for general powers of attorney, one for real estate powers of attorney. And this is only to do with the second one, the real estate powers of attorney form, that was in the House bill as passed, but the couple of changes additionally that have been agreed to by the Bar Association, the Vermont Attorney's Title Company, and the Bankers Association as well, that's my understanding. One of which, there's a couple of them, I'll just walk you through them real quick. You'll see on page 26, this is just clarifying that the model form, the way the language had been written, it seemed to limit the ability to use the power of attorney to only those 4 listed kinds of real estate transactions, sale, purchase, mortgage, gift. But it's just clarifying that, well, the party wanted to, they could have it apply for some other they could authorize another type of real estate transaction and include that as well. So that's what that language means. Over on page 27, this, you may recall, I mentioned this is lines 5 to 12, all the struck through and added language. This was the idea, remember, in the general power of attorney, the approach was changed between the bill as passed and what's passed the House and the miscellaneous bill, that instead of checking a power that you wanted to include in your power of attorney, you strike through one that you don't want to include. And so that same approach had been taken here with the real estate power of attorney form in H 878, but the parties realized, well, that's actually the opposite of what needs to happen with real estate power of attorneys. In that situation, you don't have it unless you expressly indicate that you want it. So this goes back to the original style, which
Say
is,
that again.
yes,
You don't have it unless you want it.
you don't, yes, you don't have it unless you indicate that you want it, sorry.
Okay.
Yes, if you don't expressly, proactively indicate, yes, I want it, I want my real estate power of attorney to include this power, then it won't have it. So you have to say so. And the way you do that is by checking the box.
And okay, I'm not sure I'm clear on it, but
Yeah,
it must be a wonderful idea if the bankers and everybody agreed to it.
they did all agree. I think the idea was,
Who might argue with the professionals?
I think the concept was that it made more sense with the real estate power of attorney form for you to for it to be maintained the way it was last year, which is that if you want your real estate power of attorney to include a specific power, you gotta check it.
You have to opt in instead of.
It's an excellent way to put it.
There is that everything box though.
There is another box as well for this one. The everything is in the general.
Oh, I see.
Exactly, we've got two different forms, but yes, it does have the everything. You can include all the above. So that's what's going on there on page 27. You see that the language has changed on lines 5 and 6. Instead of saying strike through each type of transaction for which the power of attorney is not given, it goes back to the original language, which is transaction for which the power of attorney is given, and then you check it if you want it.
Okay, so this goes on and on and on, right?
Yeah, but no changes anymore to the form, you mean?
Well, we got execution by guardian, use of power of attorney. Is that part of it on page?
No, that's
This
a
is
separate,
different amendment? Okay.
correct, different section, yeah.
Okay, so, Chris, anything you want to add? to
No,
this?
just ask for your support.
This is supported by the bankers and all the various groups
Correct,
that deal with real estate.
correct. For the record, Chris Delia, Bankers Association.
Any other questions about this section?
One I'd want to mention, just because it's one of those typos that is quite humorous. It's over on page 28, line 8. You remember the section was supposed to deal with self-dealing, which is when you're making a transaction with yourself. It inadvertently had said self-healing.
Well, that's important too.
It is. We may want to have a separate provision for that.
We would have to consult with health and welfare too, I believe.
That's right. One of those ones that spell check didn't catch because obviously healing's a word. And none of
That's
our,
funny.
yes, I thought it was funny. So that's being corrected.
I need that today, some self-healing. I'm going over the budget for the related agencies and I need some self-healing.
Right. Yeah, so that's that. So the next change is on page 30, and actually 30 through 32, and this is very simple. This sentence here, you may recall, these are the sections that dealt with parentage that are being moved to the other parentage bill that you have in this committee. It's H,
Right.
which is 745.
Yep.
I spoke with Michelle about that, and so she has those sections to add into that bill.
Yeah, I think it's better to have one parentage bill this year, not confuse everybody as to where to apply
Right?
changes to parentage.
Yep, that makes sense. So that is that, and then the last couple of changes are at the end of the bill, starts on page 47. And this is these sections are the ones that you discussed, Senator Sears, regarding the payment of the tax for an enhanced life estate deed. Remember, the committee may recall the way the Department of Taxes is applying the tax now is to collect the tax at the time of the transaction, the time that the life estate deed is established. But with the life estate deed, the property doesn't actually transfer at that time. It doesn't transfer until the person providing the life estate passes away. So at that time of the person's death, it automatically vests in the remainder person, and that's when the transaction is fully formalized. So I think the idea is to have the payment of the tax due at that time, rather than at the very beginning of the transaction, because it can always be changed. It didn't make sense to have the tax paid when a year down the line, they may change their mind and decide not to do it.
And I just, this brings up an important piece of legislation, quite frankly, and how it gets done. We intended for this to be done at the time of the actual transfer of property, not at the time of signing the state deed, which doesn't do anything other than say this is how it's gonna be done. But had my wife not passed away, and had I not gone to an attorney, I would have never known that the tax department had done this way. And I don't know how we keep track of our intent and how different agencies deal with it. Usually you might hear from a constituent, but I didn't hear from anyone. But yet I know that there were some people who decided not to do a like state deed based on that factor, and others who, begrudgingly paid the tax. And and you have a certain limited time, if you change your mind, to get under the current law, to get the tax refunded to you, if you decide to sell the house. So, it was always my desire to avoid probate, and so the person I was gonna leave the house to would have owed, I think it was $1,400. After we finished the late state deed, the attorney said, "Oh, well, I need the $1,400 from the property transfer tax." I said, "What?" I had no idea, and that's when we got into it. So how do you find out about this stuff? And that's the problem, in a part-time legislature, unless we hear it from a constituent or deal with it personally ourselves, we don't know how the government agency has interpreted something.
It's always been an issue, you're exactly right. Our office sometimes hears about it too, sometimes like a couple things in the miscellaneous bill, for example, because people contacted me over the summer, and then I circled back.
Is the tax department aware of this change?
Yes, because I believe Kirby was working with the tax
So
department.
if they have any comment, we appreciate them voicing your concern.
Yeah, I'll mention that.
I don't wanna get on the floor with this and have somebody ask if the tax department was aware of it.
Right.
It's a good example of our intent, which was a good one, to avoid probate with small real estate, and their interpretation. We had the thing all done, but I haven't signed it yet, because I'm waiting for this bill to pass and get that on. Darned if I'm gonna have him send $1,400, and then what if I decide to sell the house and move to Bon Air?
We should make it
Which is my
effective.
Well, if you
dream.
do, I'll be coming to visit.
Well, that's my dream.
Can we make it effective prior to passage?
Well, maybe we should make it effective on passage, actually.
I think it is.
Oh, okay.
Yeah.
I don't think we can make it effective prior to passage.
We should try, anyway.
Although we have one section here that's a year prior to passage.
That is true. One does.
Retrospective.
Yes,
Yeah.
nice.
How does that work? How can you apply a law retrospectively?
Your imagination.
There's kind of a time loop, but there is statutory authorization for that. It's actually referred to on page 50, line 10. Because as Senator Sears was saying, there is one piece of this bill that does apply retroactively. It's what I mentioned earlier, the division of the surcharge that the court's making for the two special funds. Happen to have been fortunate in this case, if I'm understanding what happened, is that the court's already been doing that, because that was the legislative intent in the first place, was to allocate the funds in that way. So this kind of retroactively provides them with the authority to have made that division, which was the original intent of the legislature, my understanding. But it's sort of a time loop situation when you do that.
Okay.
I see the wheels turning.
Okay, so
What else could we?
those are the changes that we've gotten so far. And we have, with us, folks from DCF, I believe.
Mr. Chair, I'm sorry. Before we leave this, if I could just get permission from you. So Eric has drafted language around that trail cams surveillance
Yeah.
ID, which I've reviewed and looks good. Could he send that to Ben for distribution?
Yeah, we can look at it shortly.
Okay, great.
I had scheduled, Terry Corsones and Judge Zone, but they're not available.
No, they're in the Zoom.
Oh, they're in Zoom. Well, we like them in person,
Yeah, 'cause that comes with cookies.
but that comes, yeah, cookies. We didn't get cookies. Well, we did get cookies.
We got cookies.
We got the cookies from the Southwest Vermont Medical Center.
Not as good as theirs.
Not as good as Terry's, but they're good.
Let's just say they're good in their own way.
Yeah.
So Judge Zone, and Terry, do you want, are you ready? Are you there?
Um, Good morning, Senator. Yes, I'm here. And, oh, can you hear me okay?
Yeah.
Oh, good. Oh, good. And I'll have to make a delivery next Tuesday. And Judge Zoni is also appearing remotely. And we didn't know if you would like us to comment on those sections that I guess the courts or judges would be involved in. It's not all of the sections in H 878. And in all honesty, in terms of the 4 sections that Eric just testified about that have undergone changes, there's only one section, I guess, that I would have been covering otherwise. And Judge Zoni had the same question. We didn't know if you wanted us to go through the sections relevant to us or not.
If you have any concerns or comments on what passed the House, we'd love to hear them now or any of the other sections that are new.
Oh, okay, great. I honestly don't have any concerns. We're in agreement with the language as proposed. The sections that involve court operations are 1, 3, 5, 9, 12, 25, and 45. And I'm happy to, if you'd like to just briefly, say why we're in agreement with it if you want, or if you only want to hear about things that we would request changes. I'm not for those sections anyway.
Yeah, if you can, I think we went over them with Eric, but go ahead and kind of cover the sections that are judiciary related that you'd like to cover.
Okay. And would you like me and Judge Zone to proceed kind of chronologically, which would mean I would go from like, I'm doing section 1 and 3 and he might be doing section 7, or do you want me to do mine first and then his?
Why don't you do yours first and then we'll do his.
Okay, great.
Just give us the section number.
Okay, mine. Okay, the first one I have is section 1, actually. Section 1 of the bill, and that's the court security officers. And this is for those new, that new position that grew out of S17, the courthouse security report. And these would be court security officers trained to be in attendance at hearings and trained specifically for courtroom hearings, de-escalation, response if necessary, until law enforcement can arrive. And there was a change made since the original time we testified, and that was to change the references from law enforcement functions to read judicial security officer functions. Those changes have been made, and I know, having spoken with Sheriff Anderson, the Sheriff's Association was on board, and Rob Shell had also spoken with the Police Academy. So I believe that section 1 is in agreement with everyone with the current verbiage. And then the next one is strictly in section 3, and that's on page 2. This is just a citation correction for a Judicial Bureau matter, strictly a citation correction, which is agreeable. The next is section 5 on page 3, and that was repealing recognizance for trustees' costs. It used to be that someone in a trustee process action where monies were being used to satisfy a judgment, there was a security sum of $50 for a summons returnable. It hadn't ever actually been done, and it was kind of an extraneous provision that we're fine with it being repealed. Judge Norris, Senator Norris?
Judge Norris.
Oh,
Well,
sorry.
Good morning, Terry. Just a quick question. When you refer to the court administrator shall have direct authority over judiciary employed court security officers, are those the civilian employees within the courtrooms or those sheriffs, deputy sheriffs?
Strictly civilian officers in the courtroom, not the deputy sheriffs. The sheriffs have oversight for the deputy sheriffs.
Okay, thank you.
Sure. Okay. And then after section 5, the next is section 9 on page 7. Oh, and I apologize. I was referring to as passed by the House. It looked like the pages got renumbered a bit with those changes that Eric just made. And I'm referring to the as a pass by the House, unofficial pass by the House. That section 9 is on page 7 in my version. And this really involves service for ERPO orders. And the change is just to make the service process consistent with the service process for relief from abuse orders. And it used to be that if a defendant was in the courtroom and the judge verbally issued the order, there was a requirement for law enforcement to still have to serve that order. And the feeling was if the defendant's in the courtroom, and considering how burdened law enforcement is already with service of orders, it was considered effective service if the defendant's in the courtroom and hears the order. The change is to require the court to send a written copy of the order to the defendant at the last known address, but to remove the requirement that in addition to that notice in the courtroom, law enforcement had to serve it. That's what is in effect for RFA, and this just makes it in effect for ERPA orders as well, so it's consistent. And then the next section, or the next involved, is section 12, which is the one of those that Eric referred to. And I can attest that our finance office was involved with the dates and the changes. So they're in agreement with it. Eric said he wasn't certain, but I checked with Greg Mosley, and that was language that he had suggested. And they have worked out whatever the issue was about making sure that those particular surcharges are captured.
Who got the extra money?
I don't know enough about the mechanics of it to know if there was extra money or if it was just not attaching.
The Center for Crime Victim Services has a reportedly a 300,000 deficit from this. We're considering in our budget document to do 300,000 in one time to make up for the loss. But it would indicate that somebody got the 300,000 or whatever they think they lost. So
yeah, I'm wondering if it was just never collected. I don't know for a fact
maybe it
though.
wasn't collected. I think, well, you know, as we look at the budget for 26 or the Budget Adjustment Act, it might turn up somewhere. If it wasn't collected, though, it would turn up nowhere.
Right. I can follow up with Greg Mosley to ask. I know he was in conversation with Treasury and the victims group to correct it. But I can ask him that specific question and get that information to you.
Yeah, if it just wasn't collected, then nobody got it.
I have a question for Eric. So on page 9, under surcharge, it's looks like leaving language that covers 2006 to 2008, 2008 to 2009,
Yep.
et cetera. I'm assuming that's so that if somebody is, you know, adjudicated on an offense that occurred in that time, they pay less. But why is that?
It's actually just been changed over time. Like the same way you're changing, the same way on page 10, when you're adding, you're allocating the fees differently. If you look, the fees gone up in each of those years.
Understood. I'm just wondering why we don't say, you know, I find it hard to believe we'd be processing things from 2007, like traffic things. But let's say we were in some weird circumstance, why wouldn't we just charge them what we charge now? Why would we go to the length of saying, well, back in the mists of time, you would have only paid this.
I don't think I think it's just a policy that's sort of been that way for a long time, but it's a good question. Because they say it's sort of based on when the offense was committed.
But that's what I'm saying, like, that was what, 18 years ago or something, 17
It
years
could
ago?
even be, there might be a constitutional issue with saying, we're gonna pass a law afterward that increases the amount that you have to pay. That
Maybe
could be
that's-
a ex post facto law.
Yeah, I can see that.
Yeah.
It just seems like, it's so weird that we have to, so theoretically, we'd do this another couple of times. We get 30 years out, we're still preserving the schedule for, the early 2000s.
Sure.
Anyway,
I just thought it was a reference. I never thought
no,
about
it's
it.
actually the
Terry,
law.
are there other sections you wanted to cover?
The next section was section 25. And I did actually, I've been texting Greg Mosley and I asked him about the 300,000. He said, oh, we were not giving crime victim services the correct share. We fixed that. We transfer some money based on this language. So I'm not clear on that, but I can ask him to maybe follow up with Eric so that it's clear.
At some
Okay.
point, I don't know whether we just didn't collect the money or whether it went somewhere else.
Okay.
Is this responsibility section 25 or a new section?
Section 25 is on page 31, parents' responsibility. And this was
Okay.
actually a clarification we had asked for just to make sure the courts were clear on when otherwise confidential information could be published. And that this is on section B, C2. And it just makes clear that only if a party to the relief from abuse order consents to the release of the party's contact information, or if the temporary final order is no longer in effect, it clarifies that that's when the information can be made public. There was some lack of clarification before. So that's the purpose for that change. And I think that's language we had suggested and we're in agreement with it. And then the last one just is basically the new drone cause of action. And this is section 45 on page 43. And that is just acknowledging that we usually ask for impacts on the courts if there's a new cause of action. And this places the new cause of action and the violations of it in the Judicial Bureau, which is fine. We don't anticipate an impact that we would have concerns about.
Impact on the number of cases?
Well, it'd be a new cause of action, but the Judicial Bureau feels it can handle that.
Well, are you asking for the joint fiscal office to provide I don't understand, maybe I missed something.
She's just saying she thinks it'll be fine.
Oh, okay,
Yeah.
okay.
Thank you.
I misunderstood. Don't get me wrong, I've got money in my head because I'm trying to mark up the budget today.
Got it. Yeah, not asking for any more money for that.
Okay. As long as they don't shoot down, civil.
Those were my sections, and then Judge Zoni, I know, had sections that he is involved
Thank
in.
you for joining us this morning, and we'll see you next week, I hope.
I hope so too. Thank you.
Judge Zoni.
Good morning. And
morning.
so, for the record, Tom Zone, Chief Superior Judge, I would join with Terry in saying that we have no opposition to the provisions that affect the judiciary as passed through the House budget. I'm sorry, the House bill. I can go over some of the sections with you if that would be helpful and explain the rationale.
Might be helpful.
And I will go by, I had the opportunity while Terry was testifying to coordinate it with the new version 1.1. So I'll go by draft 1.1 that Eric put together. We'll start with page 2 on section 2, line 9 and 10. That section is on disqualification or disability of a judge. It deletes the last sentence of a statute of Title 4, Section 355, to correct what is an inconsistency. Under 4 VSA Section 122, which is a broad section, it provides that anytime a judge is disqualified, the chief superior judge would then appoint someone to provide the services, including special assignments, and that's for all judges. This is a carryover from many years ago where what would happen is if a probate judge was disqualified, the superior judge would actually have to essentially become a probate judge. And that's not the practice. My position has been that 122 supersedes this, but we just wanted to make it clear by deleting that to get rid of any type of potential confusion. On page 3, for section 4, we take no issue with that. It just clarifies that it deletes the title. My question is, if you delete that on subsection B, if you take out those three words, and this is a question for Eric, I don't know if there's any header there, and I'm not sure that fits the way the statute works because there are other sections. So I just point that out. I might be missing something there, and that's something I know Eric can certainly look at. On page 8, for competency, section 10, we support the repeal. Section 11, we support the addition of a reference to the doctoral level psychologist. This is something we supported last year, and we believe that it does benefit our ability to address the issues.
Am I correct, Eric?
That first section went into sunset, yeah, and then the second one allows
Allows the doctor level.
Yeah.
There came up an issue that's been brought to us by the Department of Mental Health. You don't need to comment on it now, but it may become part of this bill. And that is the question of whether these psychologists or psychiatrists can testify remotely.
I actually heard the discussion, and I would not be in a position to make any comment on that. That is on several levels. One, I understand there's a pending case, so it would be inappropriate to comment. The second is to the extent that there would be any changes, I would not be in a position to opine as to the impact of those changes or any challenges that could be coming from them. So I've got to stay away from answering those kind of questions. I'm sorry.
Well, I kind of figured you would, but I thought I'd ask.
But on the positive side, we very much support 10 and 11. We do think it has been helpful in addressing the competency evaluations.
Yeah.
On page 34, for section 26. What this does, it continues on to page 35. Essentially what this does is it fixes a couple things. The first is it makes it clear that the Judicial Bureau does have the jurisdiction to address certain violations. The second is what it does is it makes it clear that and fixes an incongruity relating to the potential for two charges. For instance, currently, if someone uses a fake ID to try to obtain alcohol, if you look on page 35, lines 7 through 10, it provides very clear guidance that they're charged with a violation of 656, which is the underage misrepresentation for alcohol, and not a violation of this section. Section B does the same thing for tobacco and makes it clear that that's the intent and just fixes that issue which has arisen. On pages 39 and 40, it relates to the Coordinated Justice Reform Advisory Council, some language tweaks, if you will. I would note that I'm the current chair of that, and we do support that. I've also run that by the vice chair. We supported it in the House, and we think those language tweaks add clarity and are appropriate, as well as the inclusion on page 40 from lines 10 through 12 about additional information in the report. We have no objection to that. And finally, on pages 44 and 45, in section 43, this addresses a section called Repeal of Department of Corrections Pilot Project. Members of the committee may recall that there was a pilot project that was implemented in Bennington for reports to the court for PSIs before sentencing defendants and felonies. The pilot project had a report that was to be filed with the legislature. That report was filed, I believe, in December of 22. The pilot project did not, however, have was an expiration or sunset date. And the stakeholders have gotten together and requested that it be put into the bill, that it was repealed. That's so that there was a definitive time that the pilot project came to an end. And that was the consensus of all the group. And those are the only comments I have on the bill. Certainly, if there's any questions, I'd be happy to address them.
Are there any questions for Judge Sumner? Thank you.
Thank you. Have a safe day, everyone. Take care.
You too. Enjoy. All right. Now we have Sarah Robin. Well, we have, I have listed next Heather McLean, Revenue Enhancement Director for DCF. Who knew we had a Revenue Enhancement Director?
I don't even know what that means.
But
I like to say my title is aspirational. So. Hello, for the record, my name is Heather McLean, and as you just said, I'm the Revenue Enhancement Director for DCF Family Services. Thank you for providing the department an opportunity to discuss H878, and I'm here to ask you to amend the bill. And DCF is requesting the removal of language currently in Title 15, Section 3-504, the Adoption Act. This section permits consideration of the failure to pay child support as a factor in termination of parental rights proceedings. In our current practice at DCF, we do not use this consideration in our termination discussions. And we made this policy decision because it's in line with our overreaching goal to reunify families. And we also want to make sure that our analysis includes that the effects of poverty are not used against a parent, and that our commitment to trauma-informed responses to support families is embedded in our policies and statutes. So you don't have this in front of you, but currently 15A VSA 3-504-2A states that in the case of a minor over 6 months of age at the time of the petition is filed, the respondent did not exercise parental responsibility for a period of at least 6 months immediately preceding the filing of the petition. In making a determination under this subdivision, the court shall consider all relevant factors, which may include the respondent's failure to A, make reasonable and consistent payments in accordance with his or her financial means for the support of the minor, although legally obligated to do so. So striking subsection A makes it clear to the public and within DCF that failure to pay child support is not a justification for termination of parental rights.
Mr. Chair, if I might, quickly. It was very clear. I understand what you're asking. What you read said that they didn't pay in accordance with their ability to pay. So layered into that, the court made a decision based on their financial position. So if somebody does have the means and they choose not to pay, you're still saying that shouldn't be a factor. Why not? Because then poverty has no place in that particular case.
Well, I think that when we talk about going in front of, so our process, we do sometimes within family services seek child support when a child comes into foster care. And our experience is that when we move forward saying we want to pursue child support, and we do this in consultation with the Office of Child Support, that we have standards that we follow, but that the courts will honor what we are requesting. And I think the request to change the law is really just to make it clear that when it comes to termination of parental rights, that we're not holding people to this failure to pay as a reason to end their relationship with their child. That's not a policy that we practice right now. If something changed, the law would in fact allow us to do that. And so we're trying to just make it clear, both within our own department and to the public, that that's not a factor that we would consider in termination proceedings.
Understood. I guess I was asking why not, if the person is a relatively wealthy individual and they don't support their child and the child suffers as a result of that, that seems like a relevant factor. It's not poverty preventing them, it's some problem in their responsibility to their child.
Absolutely. In the law, there are other reasons that we take into account that we believe would kind of make up for that. If that were a factor, that isn't going to be the only reason that we would be seeking a termination, and therefore there would be other justification that we would bring forward to the courts that would not require or depend on the payment of child support.
Senator Bowers.
It is my understanding too that you have other mechanisms in situations like what Senator Baruch is putting out to garner that child's support, and that there may be instances where that parent shows up emotionally for that child and has other reasons that they are choosing not to pay child support.
That's correct.
Okay, that makes sense.
So basically what you're asking, like to summarize, is that the practice at DCF currently and for years in the past has been any decision to go to court to terminate parental rights does not involve failure to pay child support, and you just want to have that in statute.
That's correct.
And that's all you're asking.
Yes.
So whether that's, child support is such a dicey thing. That's why we have a magistrate. That's why we have an office that determines the child support, and have other methods like withholding your fishing license or whatever to get you to pay child support. But you just don't want to have part of the termination of parental rights.
Right.
Senator Bushy.
Thank you. So it's currently in statute, but it's not a requirement to use it as a consideration. Okay, thank you.
I personally don't have an objection.
I don't have an objection to that either.
I don't either, but
I think you raise a good point.
Yeah.
But knowing the child support system from prior, we had an awful lot of bills here on child support years ago, particularly when we were deciding to remove somebody's hunting license. It seemed like the driver's license didn't mean anything. What really got people was the hunting license and fishing license. I don't know if that's still true today, but that was a huge thing 15 years ago. Maybe.
yeah.
We did that in here.
Well, that's 258. I mean, the Fish and Wildlife Board bill blew up too. It's a cultural rallying point.
Yeah.
In terms of an instance where someone hasn't paid and it seems they do have the ability to pay, is there an ability to garnish wages?
I am actually not sure, because that would all run through the Office of Child
Got it,
Support.
okay. So you're not the right person to ask.
So we work in connection with them, but once those cases get referred, we're not involved in the collection portion of it.
Thank you.
Can you have someone send the language to Eric?
Yes,
What you're
absolutely.
thinking? Thank you. Now, Sarah Robinson.
Good morning. Morning. Sarah Robinson, for the record, Deputy Director at the Vermont Network Against Domestic and Sexual Violence. Thank you so much. I think I mentioned this in the House that Christmas is one of my favorite holidays, but Christmas tree bills are not always my favorite. So it's jumping around with a lot of different topics, but I'm going to speak to the items that are relevant to the network, and then happy to speak on anything else that you all have questions about. So I'll start with Section 6, which revises our existing sexual assault survivors' rights that are established already in current law. This is essentially a technical change. So when Congress passed the Violence Against Women Act in 2022, it included language which created a state funding incentive for jurisdictions to receive additional federal dollars through a grant program called STOP. And STOP is a grant program which primarily funds law enforcement and prosecutors in their response to crimes against women. And in order to qualify for this incentive funding, state statutes must include language that clearly states that sexual assault survivors have the right to be informed of the status and location of sexual assault kits. And though our statute has not explicitly included this to date, it is actually already current practice here in Vermont. Very briefly, unlike other states, Vermont has a very good system for tracking sexual assault kits. And that is thanks to a lot of strong collaboration that exists between the Vermont Forensic Nursing Program. You may be familiar with the term SANE nurses. They are now generally referred to as forensic nurses. And the Vermont Forensic Lab, hospitals and law enforcement. And the process for kit tracking is managed by the Vermont Forensic Nursing Program, which is operated out of the Vermont Network. So very briefly, essentially, those kits are ordered and held by the network. Before they are distributed to hospitals, they are entered into a UPS trackpad system. And like parcel tracking, when you're tracking a package that you're waiting to come to your house, that is essentially how sexual assault kits are tracked in Vermont. At every stop along the way, they are assigned a tracking number essentially, and providers at hospitals will enter information in the record of that kit when the kit is open and used. The forensic lab will update that record when it is received at the lab, and then when it is finally held by the law enforcement agency which transported the kit, that is also updated in the record. That record can only be matched in a very particular way to a medical record number, and that medical record number can only be matched in a confidential way to the name of the sexual assault patient. However, sexual assault patients can at any time contact the Vermont Forensic Nursing Program, and we can locate the status and location of their kit. So that is current practice, and this just codifies it in law and will allow the Vermont Center for Crime Victim Services to receive just north of $80,000 through this state incentive program from the Department of Justice. That's,
if I could, Sarah, if I could just ask Eric a question. So
Sure.
I see the delineation of the rights. Let's say someone feels their rights have been violated. What is their recourse?
I think that there would obviously be the ability to contact the center. And I think I would defer to Sarah on whether or not the center has a process for what would happen when someone does that. I think my understanding is that they do. So I think that's sort of the route they would take. Sarah?
It's a great question. And I would say that when the Sexual Assault Survivors Bill of Rights was proposed and passed by the legislature, it was a topic of conversation. What is the form of redress? There is no explicit form of redress in the statute itself. So yes, there are many pathways that an individual could take to understand and try to seek their rights. But I think that is an important policy question to come back to is, what's essentially the teeth that go along with those rights. It's not explicitly stated in statute as of now.
Could someone just sue the state, sue the agency?
Presumably.
Yeah, presumably, right? There's not an explicit cause of action there, but there is a general ability, there's a legal theory known as your breach of your statutory duty. So you could sue a state agency, for example, or a private actor and say the statute commanded that you required that you do a certain thing, you didn't. and you can seek a court order that the person can comply with that, yeah.
Because I thought it was great that we use a tracking system. I think that's, 21st century method of handling it. I was just thinking, stuff goes missing all the time. And I've read lots of accounts of rape kits that people believe are safely stowed somewhere, and then they go to find them and they're completely absent. So it'd be good to know what somebody has to protect their right to that.
Right.
So maybe we could ask the Joint Justice Oversight Committee to follow up. That, we also received emails, everybody in the committee anyway, from the Joyful Heart Foundation regarding the rape kit section. Very supportive of it. And, but how do we put this into place, make sure that people know where they are?
Mhm.
So that would be that would be a follow-up question, I guess. Could ask joint legislative oversight or the court, law enforcement. What,
It might be just.
I don't think about that for an amendment here.
Right.
But anyway, that's. Sarah, other sections of the bill you want to cover?
Yes, section 9, service of final orders of protection. So currently the practice is that if the respondent is present and noticed of the order and conditions at a hearing, currently law enforcement also has to personally serve the order to the defendant. And we've heard that from law enforcement that service of the orders is something that they struggle with in terms of their capacity. And sometimes this leads to long delays where a defendant does not have a physical copy of their order because law enforcement has not been able to serve it for various reasons. So this simply allows for when the defendant has been noticed on the record that the court can simply mail a copy of the order to the defendant. So we support that. Section 12 on the surcharge. I really appreciated the conversation that has been happening so far. The deposits into the Domestic and Sexual Violence Special Fund have been declining since 2013. And this is core victim services that really about half the money goes out directly to survivors. The other half funds core victim services provided by the member organizations of the Vermont Network. There were multiple recommendations in a 2022 joint fiscal report to improve the revenues in various victim special funds. The legislature implemented one of those recommendations, which was the reallocation of a $7.25 surcharge on criminal or civil judgments. You were asking earlier where that money had gone. Previously, this $7.25 went to the general fund. So last year, as Eric noted, a change was made to reallocate that $7.25 with a portion to the Victims' Compensation Fund and a portion to the Domestic and Sexual Violence Fund. And essentially the language problem prevented implementation of that. So as a result, there's a projected $300,000 deficit for the next fiscal year in the DVSV fund, which is why this language change is needed. So this will help us address the hole that exists for the upcoming fiscal year. And I just want to note that the fund and domestic and sexual violence services have been flat funded in Vermont for over 10 years. And there is still, despite this change, a major structural revenue problem with this fund. We have been filling holes year to year. But I did submit some language to the committee that we are very interested in essentially fixing this problem in a sustainable sort of way, and looking at a dedicated source of revenue that is going to be, that is not declining, and is going to perhaps be more stable year to year. And I did submit some language to you all to consider if you are looking for further amendments to the bill that would ask the Joint Fiscal Office to provide you with revenue estimates on other sources of revenue for that fund. Section 24, pages 32 to 33. This is a very small change, but one I did want to highlight, which allows a spouse to assume their maiden name. And it just clarifies that if their request is made, the judge shall grant this request, changing it from a may. And finally, wanted to state that section.
Go ahead.
Was there a question?
No.
Finally, the last section I wanted to speak to was just section 37, the Coordinated Justice Reform Council. That's pages 39 to 40. And in our view, we had offered this amendment in the House. This just truly clarifies the original legislative intent. The Coordinated Justice Reform Council just completed their first year, and we felt like this language would be helpful for clarifying the intent for year 2 and beyond. So that's all from me, but I'm happy to take any questions.
Yeah, and I'm on that council.
I have a question about that last sentence.
Yeah, and I have well, you go ahead first.
Sarah, I'm looking at page 40, lines 10 through 12.
Yep.
And in appropriations, we've gotten a number of House bills where they've done something similar, where they're putting in actual statute, the necessity to consult with stakeholder groups, which is usually assumed. I'm wondering, is there in this specific case, was there an issue with lack of consultation and you're looking for backup to be consulted, or?
Our feeling was that the Coordinated Justice Reform Council was essentially just creating processes this year to do so, and that we wanted to ensure that there was consultation kind of across the field, and make sure that that happened year to year. So I would say that there was consultation this year. It was a bit spotty, I think is a very fair assessment. And I've spoken with Judge Sone about that. And I think that they're already working hard to improve the process for next year, which is much appreciated, but we felt like this language would help just clarify.
Got it, thank you.
I'm okay with that on this, as a member of that council. I just felt like we were meeting, this year we met too late to have an impact in the governor's budget, and it's created more confusion than anything about some monies from justice reinvestment, and I'm more confused now than I ever have been about this, so anything that clarifies that. On the issue of the special fund review and report, I'm not questioning anything in your request. The only thing I'm questioning is I think I should have a conversation with Senator Cummings, and maybe you could, to determine whether this should be in the miscellaneous tax bill or the miscellaneous judiciary bill. Because this really is a taxing issue. It's not really a judiciary procedures issue. It's how do you fund a program that we've all agreed has been on shaky ground because of the funding sources being requested. So I wonder if, and yesterday was a crazy day here, as they all are towards the end of the session. And on my way to the men's room, I was being asked by somebody about these issues. And I think I responded in a rather cavalier way, which resulted in an email from the Center for Crime Victim Services, and I explained that there are necessities in this building. Our responses aren't as great as they should be. But I would next week, if we can find some time just briefly to cover this with Senator Cummings, to make sure that, number one, if she's okay with it being in here, that's fine. But if she'd prefer to put it in the miscellaneous tax bill, that's okay too. I don't think the committee has a problem with looking for a way to stabilize, and we've all been doing this for years, looking for a way to stabilize I don't think there's a problem with the language, it's where it should go.
And I personally like the idea of a surcharge on the manufacturer of
I
firearms.
thought you might like that part. I was gonna suggest you take that out.
I'm not even gonna go there. I'm not gonna.
But
I will say those are all, with the exception of the sports betting enterprise fund, which is relatively new. Those were all possible revenue sources that were included in the joint fiscal office report back in 2020.
yeah, and the sports wagering is coming in at a higher rate than we expected, but also part of those funds, sports wagering is supposed to go to prevention, and I think to a lesser or greater extent, you do a lot of preventive work in terms of preventing domestic violence and sexual assault, as well as dealing with survivors.
Well, I'm happy to follow up, Senator Sears, with you and Senator Cummings, and would be more than happy to.
You know, if next Tuesday or we can find 5 minutes to just chat with her.
Sure, that sounds great.
I'll try to, if I see her, I will try to mention it today that this is requested. Maybe you could email her with this information as well.
I will do that. Yeah, thank you all so much for your time.
Thank you. Is there anything else on H5878?
Yes, that amendment that I mentioned earlier,
Yeah, from militia, well, on the
which I think,
trail cams.
Eric, did you get that to Ben?
No, not yet, sorry, apologies.
That's right.
Let me take a moment.
It's something that they were thinking about in the House. Representative Black was talking with Representative Lalonde, and then apparently they ran out of time or something like that. So it seemed to me that if we're looking at drone surveillance, this is trail cams and putting them on someone else's property, which is just a, problem number one. But Representative Black knows at least one case where someone positioned a camera on someone else's property to surveil them. And
We make sure that
yeah.
we're talking about somebody putting a trail cam or a camera on somebody else's property, not
Exactly.
their own property.
Exactly. Yeah, there's nothing you can do if somebody
Right.
puts one on their property.
Because if I got it on my own property and I don't have one, but if I caught my neighbor's property,
Right.
I just want to make sure that's not.
And it also, I believe it has, there's with the intent of, I think. Okay.
I mean, I guess I wonder, one, how you prove intent in that particular situation, and two,
Does it have
there's.
intent? Eric, seems to me it's.
No, I don't.
Okay,
Okay,
I was gonna say, that would be a tough one, and if you're
Yeah.
putting it on someone else's property, I
right,
don't know if the intent matters,
right.
especially like without their permission.
Yeah, it mentions surveillance,
Yeah.
and then in the definition of surveillance, it seems to me layered in is the idea that you're attempting to surveil intentionally.
Yes,
For
for the purpose, I think,
For the
of
purpose.
spying, or
Yeah.
I just gave my copy to Ed to make copies, but I think that was the language,
Yeah,
purpose of observing,
I
spying.
don't plan to vote this bill out until the end of next week or the following weekend.
Can I connect with you over the weekend about a couple things I might want to pop in there? All right.
Yeah, it's usually my policy to make this the last bill that comes out of the committee, just in case something like the issue of the remote testimony comes up.
Yeah.
Other issues bills that don't do well in the House that need a place to rest, to give them another opportunity to vote
We
on.
also have the miscellaneous corrections bill now.
I know.
That's true.
I haven't, I don't know.
Got stuff I want to add to that one too.
I like the way both committees are like, you do it, you do it.
That one we should have had, but
Yeah.
the other issue is really building and I don't.
Yeah.
Process, but he just didn't want to deal with it.
Understood. I was right there, intent right there.
I just don't know how you prove intent in something like this.
Mm-hmm.
Like, would I have had to have said, like, I'm gonna spy on you with a trail cam? Like, how do you prove what someone's thought process was?
Eric,
Well, if it's directly at their,
yeah,
that might have been their intent. If it's out onto the trail, and they're
Yeah.
looking for coyotes,
yeah.
which are illegal to hunt with dogs. No.
Effective prospective.
I just feel like if you're installing sort of cameras on someone else's property without their consent,
Well,
that should be enough.
I could see, you know, you're out in a rural area, somebody believes they're on their property, or they think nobody owns the property, and they put it by a stream to observe the game, and then they get caught, and they come under this statute, and they say, well, I didn't know, I didn't mean to. Is that what you're getting at, Eric? With
Yes,
the-
you don't want an inadvertent, like somebody might
Right.
not know necessarily, they think that the boundary line is somewhere else.
That's what I'm saying.
Yeah.
Yeah. To your point, it's a lot harder to prove intent, but, you know, I'm thinking just like when people, just like when, excuse me, sir? Conducting business. So, just like when somebody puts a camera in a changing room, and gets caught, you know, there have been cases at, you know, University of Vermont Medical Center and stuff like that. It's pretty easy to prove from that footage what they're attempting to surveil, and then often they capture themselves on the camera too. So you do have video evidence in these cases, but.
Yeah, I just want to make sure, I agree with the premise, I just want to make sure it's like actually usable and provable.
Yeah.
Well, let's see if there's anybody out there who would like to testify on this particular addition to the bill. And then if you would, check with the ODG and the SA,
And I think Representative Black,
maybe Representative Black, and anybody else who might be interested. It's interesting, when we did the cell phone bill, first person to get caught was the next legislator.
right? That was the peeping Tom.
Peeping Tom.
Yeah.
Just making sure I heard right, you said, Defendant General SAS and.
State attorneys, whatever. The normal suspects, but I think maybe also perhaps somebody, I'd like to hear from somebody from Fish and Wildlife, perhaps game warden or whatever.
Mhm.
Because I know a lot of people put cameras on state property or other property just to,
Right.
watch game. I don't know if they get permission.
And I wonder if a way around that, and I can ask them when they come, is specifying that it's someone else's private property.
Yeah.
Yeah, it might, maybe better to specify it's not public property.
That's in there.
Oh,
Oh,
all
that's
right,
in there?
Yeah.
Eric's got us covered.
Well, Eric,
Yeah.
I have to admit, I didn't read it carefully enough to know that.
It's line 8.
Line
Page
8.
one.
Okay.
Just for, back under the language, it stays very closely on the drum, just the structure of the language, some of the wording to the drum. It's already in kind of a similar
Well,
idea.
I think what you can do, Ben, is just send them a copy of it. Ask if they have any comment. If they don't, that's fine.
You're talking about all the witnesses you just.
Yeah, all the people we just mentioned. If they don't have a problem with it, then I don't.
Okay, sounds good.
I don't need to hear. Senator Sheen.
Just one thought to potentially lessen the possibility of, capturing a hunter or somebody who's just, going through the woods and watching nature. On line 9, if we were to replace property with dwelling, would that narrow it a bit more to get to the underlying goal of this, do you think?
Well, it would definitely make it more specific, but it would leave out, I think what the worry was that the camera was being used to surveil the person across their property.
Form of stalking.
It is a
Yeah.
form of stalking.
So, I mean,
Oh, like if they're coming and going, or if they're in
Yeah.
the pool or something?
yeah, et cetera.
Or kids playing on the play set or.
Yeah,
Or, you know, I was thinking of the new beach in Harriman Reservoir, if you think about that.
Don't often
Puts
think
a
about
trail cam up there. That's in your district or mine now? I think it's in your
No, I think
district
it's
now.
yours.
I think the beach is in your
Are they
district.
fighting over who
doesn't have
owns
it?
the new beach?
I
That's
believe
fine.
it's, I
I'll take the
believe
new beach.
you're down at the
I haven't
house.
been, but
I gotta check that out. To see whose district it's in this summer.
All right.
I'll let you know.
no, thank you.
I get this call from the guy at Somerset, which is in Wyndham County.
Mhm.
He says, "You're my senator, you're the only one that can help me," and I said, "Oh, great," and it was about a muddy road, but the issue was, back in the day, I don't know if we were here, when the ambassador was the other representative, senator from Wyndham County, and sent during the redistricting, Senator White and I tried to move Somerset to Bennington County because it really, I mean, they go to Bennington for everything, and they
Is this
have to go
Galbraith you're
past
talking
Searsburg, huh?
Galbraith you're talking about?
Yeah.
Yeah.
So, but he stood up and said, well, how can they vote for a probate judge or county judges? And won the day, and it was ruled out of order to take them out of Wyndham County. So somehow I think they're still in your district, but.
There was the giraffe.
Well, it takes an hour to get to Dover to vote.
Yeah.
Versus 5 minutes to get to Searsburg to vote, which is in Bennington
Yeah.
County, and they wanted to vote there. We kind of, I think I've done that with our our mail voting now.
I think there's 8 people who live there?
Yeah, but I was trying to represent those 8 people, let them vote somewhere more convenient. But, so we'll check out Somerset and the Reservoir and the new beach to see which district that's in.
Very good.
Notter is very excited to have the results reported.
I'll transfer the call about the muddy roads
Thank you.
if it comes up again. That's when you feel like you're just a representative, because it's a muddy road.
There are a lot of those at this time of year.
I know.
Representatives?
Well, there's always a lot of those. I'm at muddy roads.
There's too many representatives that call the representative who represents Somerset.
Are we breaking, Mr. Chair?
We're breaking, this is an